The whole point is to make sure that the child is viable before, the unborn child is viable before making a wrongful death claim. That comes down to causation. And that is something that can be analyzed by a jury, by experts, on a case-by-case basis. But to close the door on the plaintiff making a claim for the wrongful death of her child, because we've arbitrarily set a cutoff where life is not important until it has the ability to have an arm or leg move about the inside of the womb, which is also a case cited by the defendants, what we've done is we've created a long series of completely inconsequential circumstances that shuts the door on young women who have their lives of their children taken from them as the result of the negligence of another person, and it fails to identify the true issue of bringing facts which are in question to a jury. It's the arbitrary cutoff that devalues the initial stages of human existence, and it devalues the concept of the plaintiff's ability to care for a child that has not yet been brought into this world. And we have no way of making any actual scientific determination of the standard of quickening. It is something that we've developed in case law over the years solely for the function of maintaining a fallacy. And now that the General Assembly has made it a point to protect all life at all stages of gestational development, it only makes sense that that would then be applied to our case law, our common law, which has for a long time maintained this standard for no reason other than the fact that the standard was maintained by the legislature. If the legislature is letting it go, feels like I feel and the plaintiff feels that the judiciary should also let it go and let quickening be relegated to all of the other terms of art that have been developed by case law over the years, which have been proven to be irrelevant and scientifically disprovable.
Deposition is on file with the court as part of the record now. And there are several admissions within that deposition, starting on page 61 through 70. For example, the plaintiff testifies that she never experienced any symptoms of miscarriage. She also states that it appeared as though a CT scan was necessary to assess her potential injuries, yet that CT scan was delayed because of a blood test result that showed elevated enzyme levels, which could have been indicative of a potential pregnancy. That same blood result carried with it a note to follow up for confirmation with a morning urine test to determine whether she was or was not pregnant. That urine test was accomplished and returned a negative result for pregnancy. Then the CT scans were allowed. They went forward with the diagnosis and treatment of the plaintiff in the case. That is the entire evidence that the plaintiff relies on to suggest that this plaintiff was pregnant at any point in time, an increased level of enzymes, which then turned out to be a false positive once proven by the follow-up urine analysis. Additionally, there's evidence that the plaintiff did not know that she was pregnant, did not act as though she was pregnant. This accident occurred in the morning. Earlier that morning, the plaintiff returned from a night out on the town at Macon Bar, where she had several drinks up until 2:30 in the morning. She was on birth control at the time to prevent unwanted pregnancies. She occasionally drank and smoked marijuana at this time. She does say that she had sexual relations with a friend of hers once, approximately 3 weeks before the collision. And that is presumably the time when she claims to have become pregnant. However, she is not informed the would-be father of any pregnancy or loss of the pregnancy or this ongoing lawsuit, even though that father, to the extent she has a claim, may also have a claim for wrongful death. The bottom line, Your Honor, is that there is a lot more evidence in the record now to highly suggest that the plaintiff was not pregnant, and that rebuts her blanket statement that she was pregnant. It is her burden of proof at this point in time. Even though we're at the summary judgment stage, the plaintiff must prove that she has a claim. In order to do that, she must first prove that she was pregnant, and the evidence is otherwise.